Wait a minute. Nope, don't do that. Hello? 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 Can you hear me? Let me know if you can hear me. Hello? Oh, wait, I hear me. Hello? Hello? Me? Yes, I do hear me. All right. Okay, my TV told me. It heard me. All right. Well, wasn't that a great video? What was shown? Oh my goodness, it's not fair. Thank you. Come on, Afro man. Why are you so mean? I mean, there's like three people in here. Come on. Jeez. Okay. That just. Well, at the very end of the stream, I am going to play the third video and I'll let them kick me out. I would love for you guys to go and watch these videos though, anyway, because they're so good. Like, they're just so funny. They're, they're so funny. So I'll drop the links. Right? Lemon pound cake. Pound cake. Lemon pound cake. Pound cake. I know, it's the jam. And everybody knows now it's about that officer. Oh my goodness. Let me see. Let me get these Oh, I took it down. Just a sec. Let me grab it. Lemon pound cake. Share link. Copy. Okay, here is lemon pound cake. Let me get the other song I was playing. Why you disconnected my video camera? Why you disconnected my video camera? And this is why you disconnected my video camera, the first one I played. And then the last one I'm gonna play at the end of the stream is Will You Help Me Repair My Door? And that was the biggest hit of the three was Will You Help Me Repair My Door? Okay, so moving on. You guys can't hold me back. You can't keep me down. Let's see, share screen. It didn't look like you beat me, but you did. On my end, I beat you, but now I look at my TV and you did beat me. Ugh. Show off. Oh my goodness. Okay, that was. What? Oh, wrong tab, that's why. Okay, there it goes, getting into focus. Let me. Okay, let's go to the next page. Oh, and then the last one said, order your Lick'em Low Lisa Full of Shit Phillips t-shirts from www.ogafroman.com. See what the fuss is about. I did, as I was reading these, you guys, I went to Afroman's website And none of this is on there anymore. I'm like, ah. You can get them from the only places you can get them from are like I think Redbubble. Is that the one that makes all the T-shirts? Like all the stolen design T-shirts and stuff. And then other people steal designs from the people on there. You wouldn't like where I placed the wrench-free side, so I wouldn't ask for one. So, according to the plaintiffs, Afroman, with the cooperation and assistance of the other defendants, performed, posted, and publicized these and other depictions of the plaintiff's personas for commercial purposes without the authorization of the plaintiffs to do so. The plaintiffs allege that their personas have significant value, which Foreman and the other defendants are unlawfully exploiting for their own financial gain. Hey, Christoph. In the course thereof and in connection thereto, according to the plaintiffs, the defendant made false statements, knowing them to be false, and with the intent to damage the plaintiff's reputations, cause them emotional pain and suffering, humiliation, and embarrassment. All these cops just got their fifis hurt. That's what all that means. The statements were injuries to the plaintiff's reputations. Oh, please, you guys live in a small little county. Nobody in that... no. Your reputations were not hurt in Adams County, I am certain. But you'll have to prove all that. I mean, you said it in this lawsuit, so therefore you're going to have to prove these things. So then they've got the statements, I guess, that hurt their reputations were... Foreman stated the plaintiffs stole my money and were criminals camouflaged by law enforcement. He also said in an Instagram post that the plaintiffs are white supremacists operating inside of the Adams County Sheriff's Department. Another Instagram post Afroman made said about Plaintiff Newland, used to do hard drugs, snitched on all his friends, and now he steals money from the traffic stops, bogus raids, and from the Adams KKK County Sheriff Evidence Room. Brian Newland must be the one that stole his money. Okay, let's see the next page. The next one, in Instagram, Afroman stated the plaintiff Newland stole my money. Oh, wait, no, that's the same thing. Used to do hard drugs, and that he had stolen $400 out of the evidence money. Foreman, through Instagram posts, implies with words and images that Lisa Phillips is biologically male, is trans, or is lesbian. Afroman stated through various posts that a purpose of the sheriff's department was to kill Foreman, and that the plaintiffs attempted to kill me in front of my kids, came to kill me in front of my children, and that the plaintiffs constituted a hit squad to kill me in front of my kids. So Afroman says these things in his songs. And the kids and the wife were home. He wasn't. Okay, so let's see. Now we are moving on to count one. There were 5 counts, so we're going to cover these and then we go on to the next one. Oops. Okay, in count one, I don't want to read all of this. Let's see. Plaintiffs allege the following. The plaintiffs are each law enforcement officers in Adams County, Ohio, whose names and personas are known in that community and beyond. both as public servants and private citizens. Plaintiffs' personas are distinct and recognizable within Adams County and the surrounding areas. The plaintiffs have built the distinct recognizability through years of public service and private activities and exposure to the public, often at great risk to themselves. As such, the persona of each plaintiff has significant commercial value. Significant commercial value because the reputation, prestige, social standing, public interest, and other values of plaintiffs' recognizable personas add value to any product or service with the plaintiff's personas are associated. Here's the thing though, none of this, nobody, you guys couldn't just go out and sell T-shirts with your faces as your own on them without any kind. You know what? You're not commercially viable for money without what you did. I don't know. I'm not a lawyer, so what I'm saying doesn't even matter in the whole legalities of it. I'm just kind of thinking out loud. Okay, let's see. The defendants defendant used the personas of the plaintiffs for commercial purposes during plaintiffs' lifetimes without their authorization to do so. The personas of the plaintiffs were not used by defendant in connection with any news, public affairs, sports broadcast, or political campaign, and their unauthorized use of plaintiffs' personas for commercial purposes was not justified or excused. All the defendants had knowledge of the unauthorized use of the plaintiff's personas and prohibited by a code. Defendants' actions constitute unauthorized commercial use. Defendants' actions were willful, wanton, malicious, and done with conscious or reckless disregard for the rights of the plaintiff. Not wanton. Oh my goodness. As a result of the defendant's violations of the statute, plaintiffs, as a result of the defendant's violations of the statute, plaintiffs have been damaged in the amount of profits made by defendant by the unauthorized use of their personas, have suffered embarrassment, ridicule, emotional distress, humiliation, and a loss of reputation, and are entitled to injunctive relief and other remedies under the statute. And let's see, let's go to the next page. Oh wait, no, not that page. We're skipping that one. Oops, did I go? Okay, let's see. The pertinent facts by the plaintiffs in this case are that they are peace officers who, while engaged in the search of the defendant Afroman's residence, were video recorded by Afroman, who was not there, and or others, I guess because of the home security cameras and the wife. And the video recording was subsequently publicized along with commentary related to the video afterwards. The plaintiffs further allege... Just a sec, I've got a low battery. Let me plug that in, and I'm going to forget the spot I'm at. I know I will. But I got to plug this in. All right, we're plugged in. Not going to die. All right. Let's see. I left off with the word allege. Where is... The plaintiffs further alleged that their use of their likeness was in connection with a place, product, merchandise, goods, services, or commercial activities not expressly exempted under a code. A person is not required to have air quote celebrity status to recover for statutory or common law appropriation. However, the plaintiffs, who are local law enforcement officers, have related no facts to show that their names and or likenesses have any commercial value, but they just said they did on their own. While they may be well known in their community and unquestionably are public servants who frequently come into contact with the public, this is not sufficient to demonstrate that there is any value in associating an item of commerce with any of the individual identities. And then they talk about another similar case of Urban Meyer, who I think he was an Ohio State football coach at one time. No, Urban Meyer, was he Florida or Ohio? I don't know. But to talk about a case involving him. And then they go on to say, quite simply, the court finds that there are no facts which have been set forth in the complaint which lend to the viable claim for unauthorized use of an individual's personas. The plaintiffs have failed to state sufficient factual matter, except it is true to the state of the claim to relief that is plausible on its face. So the judge ruled on this first one and said no. It looks like he ruled on some of it, and then there were more amendments and stuff, but this is all the paperwork I could find. So now we're just going to move on to count 2, invasion of privacy by misappropriation. Plaintiffs repeat all the allegations in the first one, and then they add, by using their personas, the defendant has appropriated for their own use and benefit the reputation, prestige, social standing, blah, 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 and the public interest and other values of the plaintiff's names and likenesses, which have intrinsic value in the contravention of plaintiff's right to privacy. The defendant's actions were willful, wanton, malicious, and done with conscious and reckless disregard for rights of the plaintiffs. As a result, the defendant's invasion of privacy by misappropriation, the plaintiffs have been damaged monetarily and have suffered embarrassment, ridicule, emotional distress, humiliation, loss of reputation, and are entitled to money. Okay, the next one. Okay, we don't read that page. We're going to the next page. Okay, let's see. The defendant, Afroman, is subject to liability for invasion of privacy under Ohio law when he appropriates to his own use or benefit the name or likeness of another and the name or likeness of the commercial or other value. They entered private property, right? In this case, the value that seems to be at issue here is not the monetary value of the officer's likeness, which appears to be nominal. Exactly. Instead, the issue appears to be the humiliation and outrage that the officers feel at having their likenesses displayed and mocked by the defendant. Undoubtedly, they also feel aggrieved by their investigative actions being questioned publicly. Well, you know what? You have a public office job, and therefore you're allowed to be questioned publicly. That is absolutely not against the law. In this regard, while the parties might debate the artistic quality of the defendant's videos, music, and commentary, it appears without question that they were made as part and in course of criticism, commentary by the defendant Afroman of the search and seizure that occurred at the defendant's residence. So the court in this case, found the plaintiffs have minimal interest here in the terms of the right of publicity, certainly as the public. After considering the commentary as well as the other facts contained, the court finds as a matter of law that while the quality of the appropriateness is made to be questioned, the defendant's artistic and musical renderings have substantial and creative content which outweighs any adverse effect on the plaintiffs in terms of the right to publicity. Well, so far, it seems like they're going to have a slam dunk case because it sounds like the judge is. I don't really understand why there's judge rulings in this court paperwork. I'm so confused. Hey, Rainbow. Hey, Lisa. Hey, Christoph. Okay, so. Yeah, I am not going to normally read legal papers because I clearly don't know what I'm doing. But I still wanted to go through this and read it anyway. I don't care if I don't know what I'm doing. I still find it interesting. Okay, let's see. So, finally, after balancing the societal and personal interests embodied in the First Amendment against the plaintiff's property rights, the court finds as a matter of law that the effect of limiting the plaintiff's right of publicity in this case is negligible and is significantly outweighed by society's interest in the freedom of artistic expression. Accordingly, the court finds that in accordance with the foregoing, the defendant's motion to dismiss count two is well taken and shall be granted. So count two was already dismissed? You know, I've read through these twice already, okay? So it's like the third time stuff is starting to kind of tweak in my brain and might be making some sense. All right, so we're going on to count three, the invasion of privacy and the false light publicity. The plaintiffs allege in their depictions and descriptions of the plaintiffs on social media postings and elsewhere, the defendant made statements that were false and that he knew to be false and which portrayed the plaintiffs in a false light, subjecting them to reputational injury, undue ridicule, embarrassment, and mental stress and anger. The false light in which the defendants placed plaintiffs would be highly offensive to a reasonable person. It is highly offensive to a reasonable person, but we surely can't do anything about it. It's not like you police come over and help us do anything about the trolls that we deal with doing this shit to us all day long. Huh? Anyway, sorry, off my own personal tangent there. Okay, where was I? The defendant's actions were willful, wanton, malicious, and done with conscious or reckless disregard for the rights of the plaintiff. As a result, the defendant's false depictions of the plaintiff, they have suffered the loss of reputation, embarrassment, ridicule, emotional distress, humiliation, and a loss of reputation, and are entitled to money and money and money. All right, let's see. Is this just all repeating? False light. Let's see. Okay, so now the plaintiff states. Wait, restatement towards action. Yep, that's just repeating nature of section. Okay, this is just definitions. Okay, so basically they're also saying that the form of invasion and privacy covered by the rules stated does not depend upon making public any facts concerning the private life of an individual. It is essential to the rule stated. The section of the matter be published. I don't know what that means. I guess. Yeah, let me not guess. Oh, they're giving the definitions of what highly offensive to a reasonable person means. Um, the relation to defamation. That's what they're doing here, and then they're citing a whole ton of law cases to meet the standards of what I just read in count three, the false light stuff. So that's what these next couple of pages are the definitions, and then a ton of legal cases cited. And that's also the next page. Here we go. Pending further, and I'm reading the middle paragraph on here. Pending further enlightenment from the Supreme Court, therefore the section. Wait, why am I reading this? Privacy, liability, plaintiff, and fault. Okay. This section provides that liability for invasion of privacy for placing the plaintiff in false light may exist if the defendant acted with knowledge of the falsity of the statement or in reckless disregard as to the truth or falsity. The caveat leaves open the question of whether there may be liability based on showing of negligence as to truth or falsity. And then a bunch more cases cited. A bunch of legal jargon. Here we go. The Ohio Supreme Court publicity that has recognized publicity that unreasonably places others in a false light before the public as one of the four separate branches of tortious invasion of privacy. There are certain requirements for a false light claim. First, in a false light claim, the statement which is the basis of the claim must be true. Secondly, it must be publicized, which is different than published. Publication, in that sense, is a word of art, which includes any communication by the defendant to a third person. Publicity, on the other hand, means that the matter is made public by communicating it to the public at large or to so many persons that the matter must be regarded as substantially certain to become one of public knowledge. One of public knowledge, which means any communications, which may be oral, written, or by any other means. It's one of communication that reaches out to the or is sure to reach the public. And then they talk about the misrepresentation made must be serious enough to be highly offensive to a reasonable person. In this regard, the publicity given to the plaintiff has placed him in a false light before the public of a kind that would be highly offensive to a reasonable person. In other words, it applies only when the defendant knows that the plaintiff, as a reasonable man, would be justified in the eyes of the community in feeling seriously offended or aggrieved by the publicity. The restatement also accounts for multiple claims arising under the same set of facts. The interest protected by the section of the individual not made to appear in other words. Okay. Basically, they say that they're just saying that I guess there is reason to see that it could be false light. Just a sec. The court finds that there is a tribal issue in this case for the false light violation, and the claim can go forward. Okay. All right, I think I'm catching on. But I had to go a few pages up. Okay, so I think I don't need to go into more detail of the false light, but I'll show you where I just read that. Actually, now that I know what I'm doing here more, we're going into count 4, the invasion of privacy. Um, the judge with the on count 4 said, look, I am sorry, I'm just catching on to the best way to read this for all of us to understand it better. It says that the plaintiff's allegations is set forth on the count 4. The court is unable to say that it appears beyond a doubt from the complaint that the plaintiff can prove no set of facts entitling them to recovery under the publicity theory of invasion of privacy. With these standards in mind and in reviewing the plaintiff's allegations as set forth above, the court is okay. So I guess count 4 is not going to be presented in court. And now count 5 is defamation. And let me just make sure I read anything good on this before we. It says many of the statements published by Afroman were false. They were known by the defendant at the time of their publications to be false and were published in spite of that. Specifically, the statements that the plaintiffs stole money, that Foreman stole money. I'm sorry, specifically specifically Afroman's claim that the police stole money from him and that they were going to kill him in front of his children or kill him anyway. That there was a hit squad sent. That they were white supremacists, that they are criminals, that they used to do hard drugs or a snitch, that they steal money from traffic stops and bogus raids, that there was $400 stolen, and that one of them is not a female and is a trans or a lesbian. These are all false statements. These and other statements the Afroman made and were published with actual malice. The defendant knew they were false and published them anyway in order for the purpose of injuring the plaintiffs. And now let's see his ruling on the defamation. To establish a claim for defamation, the plaintiff needs to show false statement of facts were made about the plaintiff. The statement was defamatory. The statement was published. The plaintiff suffered injury as a proximate result of the publication, and the defendant acted with the requisite degree of fault in publishing the statement. A statement is defamatory if it reflects injuriously on a person's reputation, or exposes a person to public hatred, contempt, ridicule, shame, or disgrace, and affects the person adversely in his or her trade, business, or profession. And now we've got a case law. In contrast, let's see, the plaintiff. Oh, okay. It says the determination is very. Let me get to the last page 33. Here we go. All right. This determination is very difficult to make on a motion to dismiss. Many of the statements referred to by the plaintiffs appear to be exactly that, statements and not opinions. So, This court cannot conclude as a matter of law at this point in the proceedings that the statements made by the defendants were not made with actual malice. Furthermore, the court cannot find beyond doubt that the complaint that the plaintiffs can prove no set facts entitling them to recovery as to count 5. Pippi, what does that mean? Judge, what does that mean? The court cannot conclude. So it sounds to me like the court cannot find actual monetary defamation? And then the last count 6 was for injunctive relief. And they can't really consider that now because that's like the money part, I think. But it doesn't say anywhere how much money. So let me see the summary and comments. Okay, so court counts 1 and 2, the plaintiff can prove facts entitling them to recovery and a judgment of dismissal shall be disentered. So 1 and 2 were dismissed on this. And then counts 3, 4, and 5, it is unable to find at this stage that the plaintiffs can prove no set of facts entitling them to recovery. So it sounds like they're going to continue with complaints 3, 4, and 5 in court. And counts 1 and 2 were dismissed. And then count 6 is what do they call it? Injunctive relief. Ziggy, what does injunctive relief mean?
Injunctive relief is a court order requiring someone to do or stop doing something specific. It's used when money
can't fix the
problem and harm needs to be prevented.
They can't find cash, but they might find reputation harm. Okay. Thank you. And we just heard what Ziggy said about injunctive relief, so I guess
You're
that's
absolutely right. Reputation is often more valuable than money.
Ziggy, stop. Do not agree with Pippi. She doesn't like you. Jeez. Him and I are going to have a talk after this. Anyway. All right, so now let's just go on to the other one should be a little bit quicker to read. Judge Jerry R. McBride is the judge for the case. Okay, come on. What are you doing to me here? All right, here we go. Hey, not that Lauren Marie. Good luck. I wonder how that's going to go for you, what you're going to hear. Because I got stopped twice. It will take away Afroman's right to monetize. Oh. Gotcha. Thanks, Pippi. Okay, so this is Sean D. Cooley et al. And the plaintiffs versus Joseph Edgar Foreman, aka Afroman et al. This is a brief of a motion to dismiss and strike plaintiffs' complaints. I couldn't find a date this was filed on, so I couldn't tell if I should read this before or after. But this case is a classic entry into the slap suit genre, a meritless effort to use a lawsuit to silence criticism, and not just any criticism, but the criticism specifically of government actors. Plaintiffs are a group of law enforcement officers who executed what appears to have been a highly destructive and ultimately fruitless search of a popular musician's home. Now they find themselves at the receiving end of his mockery and outrage, expressed through a series of music videos about the search, as well as a spin-off merchandise and social media commentary. They ask this court not only to award them damages, but to order him to stop speaking about them. At the granular level, the complaint is an attempt to shoehorn the facts into a series of torts meant for the purposes other than plaintiffs, and it fails simply because it does not provide allegations that could fulfill the requisite elements of any claim. Conceptually, their allegations run afoul of a much deeper principle. There is nothing the First Amendment protects more than jealousy, than criticism of public officials on a matter of public concern. As plaintiffs allege, in August of 2022, they executed a search warrant at the Adams County home of Joseph Foreman, a rapper by the stage name of Afroman. Mr. Foreman's wife, Afroman's wife, recorded the search, as did several security video cameras on the premises. Subsequently, Mr. Foreman created a series of music videos about the plaintiff's search. In their complaint, plaintiffs provide links to two of these videos and acknowledge that they feature footage of the search. The footage shows Mr. Foreman's front door being smashed in, officers coming through his home with weapons drawn, and officers searching through his clothing and personal belongings. Which I think you guys, which some of you that came in early or that were here for the other videos saw that in the videos probably before they were cut off. So dirty. I was willing to give up all my big money that I was going to make from this video. I was willing to give it all up in the name of the art. Nope. Afroman doesn't want my Ohio money. This video also contains Mr. Afroman's narration overlaid over the videos and sets of music. His lyrical comments range from rye, "Would you like a slice of lemon pound cake?" asked as an officer is shown doing a double take at a dessert sitting on a kitchen counter, to mocking, "Any kidnapping victims inside my CDs?" to outraged, "Did you have to traumatize my kids? Will you pay me for doing me wrong?" He denounces the officers' seizure of cash. "They ran up my driveway with guns and hate to steal my funds." Oh, I need to go to the next page. Sorry. There we go. "They ran up my driveway with guns and hate to steal my funds," and questions the propriety of their actions. "Why are you disconnecting my video camera?" I'm singing it. "Why are you disconnecting my video camera? Why are you disconnecting my video camera?" Plaintiffs who also allege that Afroman's commentary has continued on social media in the form of references to the videos mixed in with insults aimed at the officers, as well as the judge who Afroman claims signed the warrant permitting the search. They also allege that he is selling merchandise containing references to the video footage of the search of his home, t-shirts of Officer Poundcake, a reference to the videos. Plaintiffs do not identify the substance of any particular statement in the videos, or for that matter anywhere else, that they claim is false. Instead, the central focus of their complaint is that Afroman is making money off of his video commentary and related merchandise, and is criticizing plaintiffs harshly in the process. That is not tortious conduct. It is protected speech. Moreover, it is nothing short of absurd for the plaintiffs to claim that Afroman has somehow invaded their privacy. By their own account, the plaintiffs are law enforcement officials who were engaged in official business at the time of the search shown in the videos. They were in Afroman's home, not their own. Nothing about Afroman's expression involves matters of the plaintiff's intimate personal privacy that could be protected by law. To the contrary, his description and criticism of their police work is a legitimate matter of public concern. The plaintiff's case should be dismissed. And give me just a moment here. Okay, so let's see. As discussed below, the plaintiff's claims rest largely on a series of bald legal conclusions that are at best untethered from and at worst inconsistent with other factual allegations. Further, they fail to allege any specific statements that they maintain are false. Okay, so now they're talking about the counts 1 and 2. Maybe this came first. Like, do I need to read all this? Let's see. Just a sec. Okay, just. Okay, read the introduction and background. Okay, let's see. I don't want to read as much of this as I did the last one, but I want to make sure I don't miss anything good. The plaintiffs do not and cannot allege that those elements here. To the contrary, the core nature of their first two counts is inconsistent with the First Amendment. Okay, so the judge actually made a decision on that, though, on the first two counts. So why would I read all those? Oh, I think I really did. I think I did this backwards. Yeah, I did because this is just going through like the plaintiffs do not properly allege a claim for false light. And then they talk about the false light one, and I don't think. Let's see. That's weird. Oh, and then they do include the lyrics to Will You Help Me Repair My Door? At the very end of this. This is basically, I don't think I need to go through any of this because I just went through the plaintiffs and we found out what the judge is going to go ahead and hear on Monday, so I don't really need to read this one. I shouldn't have done it backwards, but I did, and maybe that's good. I don't know. Who cares? Here we are where we are. So, these are the lyrics to Will You Help Me Repair My Door that were included at the end of this. And I am going to play, as soon as I'm done with the stream, I'm going to play this video. But I would like to read the lyrics out because they're going to cut the video. And this was the most popular song of all of them. So it's called Will You Help Me Repair My Door? And it starts out, Will you help me repair my gates? Will you help me repair my door? Did you find what you're looking for? Will you help me repair my gate and my door? Would you like a slice of lemon pound cake? You can take as much as you want to take. There must be a big mistake. Would you like to have a slice of my lemon pound cake? The warrant said narcotics and kidnapping. The warrant said narcotics and kidnapping. Are you kidding? I make my money rapping. Why does the warrant say narcotics? Well, I know narcotics, but why kidnapping? Let me tell you something, officer. Any kidnapping victims inside my suit pockets? Are there, say, any kidnapping victims inside my suit pockets? You crooked cops need to stop it. There are no kidnapping victims inside of my suit pockets. Let me ask you another question. Is there 1,000 pounds of weed in my suit pockets? Is there 1,000 pounds of weed in my suit pockets? You crooked cops need to stop. There is not 1,000,000 pounds of weed in my suit pockets. Let me ask you something else. Are there any kidnapping victims inside my CDs? Any kidnapping victims inside my CDs? The Adams County Sheriff Department, you can get these. There are no kidnapping victims in my CDs. How many pounds of weed are inside my CDs? How many pounds of weed are inside my CDs? Adams County Sheriff, you can get these. How many pounds of weed are inside my CDs? Why are you stealing my money? Why are you stealing my money? You represent the law and it's funny. You keep stealing my legal, work hard every day, pay taxes money. The sheriff disconnected my cameras. The sheriff disconnected my cameras. The sheriff should be locked up in slammers. The Adams County Sheriff Department disconnected my cameras. Hi, Kimmy. Did you have to traumatize my kids? 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 Will you pay me for doing me wrong? Will you pay me for doing me wrong? Will you pay me for doing me wrong? Or will I have to get paid from this song? You think they gonna buy this, man? Why you disconnected my video camera? Oh, and then this lyrics to Why You Disconnected My Video Camera, which I played that, but I'm going to read them anyway, because since they got rid of it, I'm going to read those lyrics too. Why You Disconnected My Video Camera, another song. The British are coming, hide your money, your kids, and your woman. White supremacists on my premises. What is this, a racist feminist? Why you disconnected my video camera? Why you disconnected my video camera? Why you disconnected my video camera? We ought to throw crooked cops in the slammer. Why you disconnected my video camera? Why you disconnected my video camera? Why you disconnected my video camera? We ought to throw crooked cops in the slammer. August 21st was the day that the Adams County Sheriff destroyed my gate. They ran up on my driveway with guns and hate to steal my funds. They just couldn't wait. I know you want me dead or in the slammers, but why you unhooking my video cameras? Rent a cops for rent, digging in my pockets for lint. Unconfidential informant, false accusations on the warrant, any pounds of weed in my custom suits, any kidnapping victims in my gator boots. What do you see in my CDs? Look at the screen. Can you see D's? Why do you see what do you see in my CD books? You can't see me, but I can see you crooks. The British are coming, hide your money, your kids, and your woman. White supremacists on my premises. What is this, a racist feminist? Why are you disconnecting my video cameras? Why are you disconnecting my video cameras? Why are you disconnecting my video cameras? They ought to throw crooked cops in the slammer. Why are you disconnecting my video camera? Why are you disconnecting my video camera? Why are you disconnecting my video camera? They ought to throw crooked cops in the slammer. Cops in the slammer. Share snake, quadruple take, TikTok famous, Officer Poundcake. Speculator hater, any kidnapping victims in my refrigerator. Congratulations, TikTok star. Now the world knows how stupid you are. Lucky you're a family guy. Got the munchies because you got high. You never catch white people breaking in my house, but you can traumatize me, my kids, and my spouse. You can steal all the money from me, man, but you can't solve the murder in Seaman. Oh, does he live in Seaman, Ohio? Okay. Mad because I'm black, mad because I'm rich, mad because I fucked your drug addict bitch. I came from LA and bought the whole city. Send your wife home drunk with my name on her titties. The British are coming, hide your money, your kids, your woman. White supremacist on my premises. What is this? A racist feminist. Why you disconnected my video camera? Why you disconnected my video camera? Why you disconnected my video camera? We gotta throw crooked cops in the slammer. I pay taxes, I work daily, I get raided by Beetle Bailey, Randy Walters' private pile. I used to fuck his wife doggy style. Fidel Castro, let's see. Duck Dynasty, let's see. Duck Dynasty, Uncle Jesse, Officer Receding Hairline, Deputy Dipshit, can't find shit. Lieutenant Mona Lickamlow Lisa, ate my ex-wife just like pizza. She jealous of me and my log jam. That's why she disconnected my camera. Pubic hair, Paw Patrol, bring back that money that you stole. I defund thee, refund me, fuck you and King Kong Bundy. The British are coming, hide your money, your kids, and your woman. White supremacist on my premises, what is this? A racist feminist. And then why you disconnected my video camera verse again. And he doesn't have Officer Poundcake words? Why isn't Officer Poundcake included? Really? Will you help me repair my door? Why you disconnected my video camera and no lemon pound cake in here? Alright, that's too bad. Let's see. Let me drop the lemon pound cake link again. Share. Copy. I'm gonna beat Pippi this time. Gonna beat her this time. Ha 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 ha. A peach. I win. Granted, I have 30-second head start, but whatever. Okay. So, any questions for that riveting? At least it wasn't anything to do with this crazy community that is on steroids right now, and I'm sure we're going to get some more of it. If somebody's not even live right now, I don't even know. Hey, Kendra. Perfect timing. I'm just getting ready to end it. It was kind of boring anyway. I mean, parts of it are good, but legal stuff. But I'm really excited to see what happens Monday. I am renting a car next week for sure. It's just that I have to do other things. I have to go to Michigan and I have to go to West Virginia. However, the courthouse is literally 2 blocks out of my way on my way to West Virginia. So I could, Monday I wouldn't be able to go, but Tuesday I could. I could rent my car Monday and go to Michigan, and then Tuesday I could go to West Virginia, but I could leave so early that I can stop at the courthouse and, have a listen in, maybe. If it's not crazy crowded and stuff, which I don't see why it would be because it's in podunk nowhere. And the only hotels that are near it, there's 2 hotels near it, and both of them are $72 a night. So they're not the kind of hotels that would really meet the standards of a lot of people that want to come visit Ohio, or that would come to Ohio anyway, I would think. Yeah, I really am too interested in this case and seeing what happens. I apologize that I'm so uneducated in reading court paperwork that I didn't do that good of a job. Oh, Kendra, that's funny. I go to the same place every time I go, so it's all good. It's all good. But Yeah. So I'm gonna end the stream by playing the "Will you help me repair my door" video. And we all know what's gonna happen, that it's just gonna, deny us. Let me drop the link for that video so you guys can copy. So you guys can also watch this video yourselves too. And I hope you guys go watch all 3 of them. They are such good videos, and he really does deserve all of the clicks and all of the views on this, for real. I just wish he wouldn't shut me out of it, because I was willing to give all of my millions of clicks and views money to him for it. That whole 10, 15 cents I could possibly earn, which I wouldn't, but like maybe like you get 50 cents, I get 50 cents for 1,000 views. So yeah. All right, but thank you guys for paying attention and hanging out, and hopefully this got you guys off of, your mind off of community shit for a few minutes, which is, we kind of need a little refresher from the bullshit at times. So anyway. All right, so you guys have a great night, and let's see, let me share this tab. Oh, wait, you know what? Let me here's another video to watch. I forgot. Let me see. Is it this right here? Ray William Johnson. He actually does a much better job. Watch this video too about the case. I'm sorry, not that, Laura Marie, but there's way better stuff to catch up on today. Oh my gosh, there was some craziness today. Craziness. Somebody got served a whole plate of whoop ass verbally, and it was beautiful. All right, everybody, have a great night. Thank you. I'm sorry that I'm getting ready to end this just as you're catching up, just as Not That Lauren Marie catches up, and just as Kendra comes in. So I'm sorry. You guys have a good night. And yeah, I will be back definitely to give updates on this for sure. Okay? So thank you. Have a good night, and watch this until they shut me down.
Will you help me repair my gate? Will you help me repair my door? Did you find what you was looking for? Will you help me repair my gate and door? Would you like a slice of lemon pound cake? You can take as much as you wanna take. There must be a big mistake. Would you like to have a slice of my lemon pound cake? The warrant said narcotics and kidnapping. The warrant said narcotics and kidnapping. Are you kidding? I make my money rapping. Why does the warrant say narcotics? Well, I know narcotics, but why kidnapping? Let me ask you something, officer. Any kidnapping victims inside my seat pockets? Are there any kidnapping victims inside my suit pockets? You crooked cops need to stop it. There are no kidnapping victims in my suit pockets. Let me ask you another question. Is there 1,000 pounds of weed in my suit pockets? Is there 1,000 pounds of weed in my suit pockets? You crooked cops need to stop it.
You know what? I'm going to go ahead and end it here before they kick me out of it. Because when they kick me out, it's harder to end the stream. So it's probably just better if I do it this way. Just kick myself out of it. Again, here's the link for this video. Oh, wait, no, that's Ray's video. Yeah, scroll up if you want links. Anyway, thank you guys very much again, and I will see you all in these crazy, crazy streets.